This is an appeal of a first-degree murder conviction. Mr. Morganti was convicted after a jury trial of killing one Anthony LeConte. It was a homicide which occurred on May 10th of 1988. And there are two appellate issues that I would like to discuss in argument this morning without waiving any of the other points in my brief. The principal issue advanced on appeal, the first one concerns a Miranda issue. And in this case, by way of very brief background, a trooper Copenrath of the state police executing an arrest warrant went out to California, and he went to a Modesto jail where Mr. Morganti had been apprehended on unrelated charges. And as a result of a fingerprint match, that's how Trooper Copenrath arrived there. And in this setting, he first indicated to Morganti after greetings and the like that he knew his name was Robert Morganti and that he was not the person known as Roderick Grenage. That was an alias which Morganti was using at the time. And the bottom line for this appeal is whether or not Morganti properly invoked his Miranda rights at the jail such that any statements which followed after, including at another location at a sheriff's office, should be suppressed. And the statement in question that Morganti made is, quote, and this is according to Trooper Copenrath, I'm thinking I might need a lawyer and want to talk to him before talking to you. And the first thing I'd like to make clear from our point of view is, under Smith versus Illinois, one should not blur whether or not this was a proper invocation with whether or not there was later a waiver of rights. In other words, the court, and I suggest the trial court did this improperly, didn't just look at that statement and decide whether or not that was a proper invocation. Judge Giles also then looked at post-response statements and conduct in concluding that the statement he made was equivocal. But
why is that? I guess I don't understand if you're trying to interpret the words that you are focusing on and they have some ambiguity. Why is it totally, why can't she, what immediately follows she can't look at?
Not if it's prompted by a further comment by Trooper Copenrath. In other words, here Morganti said, I'm thinking I might need a lawyer and I want to talk to him before talking to you. Trooper Copenrath then says, you want a lawyer? None of this is recorded, unfortunately. A part of it is later recorded. And then after Trooper Copenrath makes this statement, you want a lawyer, then comes further conversation about, I want to be moved to a more comfortable location. My point is, and I think Smith versus Illinois makes very clear, this court's task, and it should have been the trial court's task, is to first decide the invocation issue, not the waiver issue. You don't blur the two. So that if Morganti unambiguously invoked his right to counsel by saying, I think I might need a lawyer and I want to talk to him before talking to you, then the court cannot consider anything that comes after that in determining whether there was a proper invocation. The court might consider post-responses as other courts have done, including this one, in terms of was there a waiver of the invocation. But it can't consider the post-response conduct in terms of the invocation issue.
But isn't that argument dependent upon our finding that it was a clear enough invocation?
Exactly.
Right.
Okay, so you're saying that if he had said, I want a lawyer, then if the officer had then said, "Do you want a lawyer?" then we should essentially ignore that.
Right.
But if it were ambiguous as to whether or not he was requesting a lawyer, would it not be appropriate then for the later question intended to resolve the ambiguity to be considered in determining whether there was truly an invocation?
Right.
I think I agree. I think if you conclude that his first statement is ambiguous, then perhaps it's appropriate, as the court did in Dubois, to go on. On the other hand, if you conclude that his first statement was unambiguous, the United States Supreme Court has made clear you can't consider post-response conduct and statements.
So then isn't the question that needs to be answered, was that first statement ambiguous or not?
Yes. And what I say is, in my opening brief, I rely upon this court's decision in Commonwealth versus Contos. That case, having canvassed all of the law of this state and, frankly, all of the law in the federal and state jurisdictions across the country, seems to fall almost right on point. Contos, the words were, quote, "I think I'm going to get a lawyer." And the SJC in that case held that was a proper invocation of the right to counsel.
Of course, in that case, the statement, "I think I want a lawyer," is somewhat of a colloquial, or was viewed as a colloquial way of speaking. It is, it's almost an expression of present intent. I think I'm going to go to the store. I'm getting ready to do something. I think I want a lawyer. This statement that this defendant made, "I am thinking I want a lawyer," is really almost descriptive of a thought process. You've just advised me of my rights. One of the rights was if I want a lawyer, I can get one.
Says, I'm thinking I might need a lawyer.
Because I think I might need one. And now he's saying, I am thinking that I might want a lawyer and I might need one. And so isn't that equivocal in the sense that it is descriptive of a thought process?
I don't believe so, and I'll tell you why. In addition to saying, "I'm thinking I might need a lawyer," he added, "and I want to talk to him before talking to you." So that's more than you had in Contos.
No, that isn't an exact quote, is it?
I'm
thinking I might need a lawyer and to talk to him.
And want to talk to him before talking to you.
You could read that as, "I'm thinking I might want to talk to him."
Well, and want to talk to him before talking to you. This is the best we have from Trooper Copenroth. And remember the Davis case, a defendant is not required to speak like an Oxford Don. That's the quote. And what I would say is, I have found numerous cases. The 11th Circuit said, "I think I should call my lawyer." That was proper. The New York Court of Appeals, "I think I need an attorney." That was proper. North Carolina, "I think I need a lawyer present." Minnesota, "I think I'd rather talk to a lawyer." And then Virginia, "I think I would rather have an attorney here to speak for me." And in that case, the Virginia court had a very interesting discussion about think. And there, the Virginia court explained that the word think, quote, "contains no ambiguity. The word think is generally defined to have in one's mind as an intention or desire," quoting Webster's dictionary. Mm-hmm. So the Virginia Court of Appeals held think is not ambiguous. It's not like other statements like Dubois, Obershaw, those lines of cases where maybe. It's, "I think I need a lawyer," and I think most importantly, "and I want to talk to him before talking to you." So that's what we have, and looking at Contos and other cases like it around the other jurisdictions, we contend that that was a proper invocation of his Miranda warnings. Having done that, the question becomes who initiated any further conversation. Under Edwards, if the police initiate any further conversation, you can't find a proper waiver. It's presumed to be an involuntary statement once he's properly invoked his right to counsel. And here, there's no question on the record that Trooper Copenrath is the one who then pressed with clarifying questions when, if you find the invocation was proper, there was no need for clarification. I also would say in Edwards, it's clear, merely because he responds to later questions is not sufficient to make out a waiver. Edwards says that very squarely. So any conduct after, in terms of just sitting down and talking, does not make out a waiver. And the court must be aware that even when he was moved, he was still resistant to talking, and he refused to sign an acknowledgement form at the jail. He refused to sign anything at the sheriff's office, and then he re-invoked his right to counsel, saying, I would rather have my lawyer here than talk to you. So the evidence...
Wasn't he being videotaped?
He was being videotaped.
Didn't he participate in the videotape voluntarily? Didn't he acknowledge that the camera was rolling?
That's very unclear. The trooper, and I have the videotape with me, the trooper twice asks, is the videotape on? I don't know, guys. And so to say that the defendant knew it was on when even Trooper Copenrath didn't know it was on is an issue. And I have the tape because at one point, in response to your question, the transcript says, do you see the videotape up there? And he shakes his head no. I've looked at that 3 times last night. I never see him shake his head no. I don't care. The question was, you don't mind, do you? And the transcript says he shakes his head no. Not only do I not see him shaking his head no on the videotape, but then all of a sudden the tape cuts. There's a jump cut. And it's indicated in the transcript, tape snaps. So jump cuts right when they ask, you don't care if you're being taped, do you? I don't see him shake his head no, and then there's a jump cut in the tape. There are 2 jump cuts in the tape. So I don't know technically what happened with that. This was mentioned in my brief and in the lower court. But I have the tape so that the court can see that I couldn't observe a shaking of the head no. But the point is, by then, Copenrath is still talking to him. And yes, there is a videotape, but it's certainly unclear from this record that even the trooper didn't know whether or not it was on or not. And that's why we have this other argument about he didn't know he was being recorded when the trooper left the room, and then he has this whole conversation that's being tape recorded, he says without his knowledge, where he tells, and this is the really prejudicial comment, tell my son I did a really bad thing a long time ago. That's harmful error because any statements that the defendant allegedly made to friends, this is what the Commonwealth, in one paragraph, they've basically said, no harm, no foul. Anything he said to friends was being rebutted at the trial with credibility issues because any number of suspects here might have been involved in the homicide other than Morganti, whether it was Tessier, who set up the bogus drug deal, Travis Merritt. All of these people's credibility was being effectively attacked by defense counsel, but there was this statement on this tape in the middle of this interview where he, from his own mouth, says, I did something bad, tell my son I did something bad a long time ago.
Did the jury see the videotape?
Yes, they saw a redacted one, and I have it. This one, which I'll hand up to the court, is, from what I can tell, this is what the jury saw, because it doesn't have the Miranda warnings.
Is that the exhibit, or is that a copy?
This is a copy. I can have it transferred from Brockton. This is what Mr. Reddington had supplied.
Mr. Harwood, we look at everything, so we will look at the full, we'll just get everything.
Okay, this is the redacted videotape because the judge did suppress everything after he again said, and I'd really rather have a lawyer, when he said it at the interview room. So
Could I ask you this question? Is there any, and maybe you've cited it and I just didn't catch it, if you have a statement by a defendant that is ambiguous with respect to whether he's invoking or not his right to counsel, is there any law that sort of says, you know, if there's ambiguity, the presumption is to decide the ambiguity in favor of the defendant, or anything is sort of, you know, shifting the balance at all, or sort of law on shifting the balance at all?
Well, your cases, Dubois and Oberschon, those then begin to go into a waiver analysis because you found that it's an ambiguous invocation. And on the waiver analysis, what I would say is there's Edwards saying that merely responding to further questions is not enough to show waiver.
I guess this is what I'm looking at this statement. He was thinking that he might need a lawyer and want to talk to him before talking to you, and Justice Spina has talked about he was thinking he might need a lawyer. So putting that aside, but and want to talk to him before talking to you, you know, he was thinking he might modify that or not? I mean, it's a pretty ambiguous. One could interpret it ambiguously.
I don't think there's anything.
You don't think
I
it's
don't
ambiguous?
think it's ambiguous, and I especially don't when you add the words "and want to talk to him before talking to you." Now, interestingly, I did find, and I've included in my brief, a Minnesota case where the police did not make a recording of it. And this interview did occur before this court's decision where you indicated henceforth, you know, you have to video and tape record confessions. And in that case, and I think it's applicable here, if they didn't make a recording of these Miranda warnings and exactly what was said, then that has to inure to the benefit of the defendant. And in the Minnesota case, Munson, the court said, hey, there's no recording here. That's got to weigh as an inference in favor of the defendant because the police could have made a recording. Here they did make a recording of a part of the confession, but not any of the reading of rights that we're talking about now, nothing at the jail. So there is the Munson case, and there's Edwards, and then there's, of course, Johnson v. Zerbst from time immemorial that there's a presumption against waiver of constitutional rights, so any inferences would be drawn in favor of the defendant.
But the standard is that the assertion of the right has to be unequivocal. Isn't that the word?
Yeah.
If it's not unequivocal,
Right.
then
it
goes out.
But then if it's equivocal, then you get into issues of was there a waiver of right? And that seems to be how...
It's standard Miranda after that.
Yeah.
But it's Edwards v. Arizona. If it's an unequivocal assertion of the right to counsel, it's Edwards v. Arizona.
Yes. And then Edwards says, you know, if it's unequivocal, then police shouldn't initiate further conversation. But if the defendant does, then you get into a waiver analysis. Mm-hmm. And that's the difference, and that's why I cite Smith v. Illinois. You don't jump to a waiver analysis if there's an unequivocal invocation and the defendant isn't the one who next speaks.
Now, is it implicit in that a law enforcement officer errs if he asks, as happened here, the defendant whether he intends to waive his right to counsel if there is something which a reasonable officer would believe to be to be unequivocal?
Whatever's in his head, you look at this and you see the trooper continuing.
Right, I understand. I guess my question is, it seems by your logic by your analysis, that it would be wrong for a law enforcement officer to make further inquiry as to whether the individual wishes an attorney.
Right.
If a reasonable officer, having heard what he heard, would have understood that to be an assertion of rights.
Yes. Yes.
And I guess my question then is to you is, was it unreasonable for this officer, in view of what was said, to then go on and say, do you want an attorney? Was that an unreasonable thing for this officer to do, having heard what he just heard?
Yes. Stated differently, there was no need for a clarifying question if you have an unequivocal assertion of right. It's just a means to continue the interview. And even after the second time he said, no, I really want a lawyer at the sheriff's office, the trooper continues to try to talk to him. that got suppressed, but looking at the whole circumstance, you see even after a second time comes, the conversation goes on and on and on, even after that.
You're out of time, but could you just identify the second issue you wanted to talk about?
The second issue was they excluded Mr. Morganti from the jury view. I know under Snyder, in a 5-4 decision, they said due process doesn't require the presence as long as a fair trial can be given. This decision was echoed by this court in Evans. It's not absolutely required as long as a lapse wouldn't prejudice the defense. And my point here is this was no ordinary view. This was a view where there was a mannequin in the car, there was a rod through the head to show the trajectory of the bullet because the Commonwealth was trying to establish that Brian Madden in the driver's seat didn't shoot him. Morganti behind in the rear seat shot him. So, and the prosecutor got in the car during the view and showed various measurements and distances to the jury. And the trial judge's fear of flight, we contend, was not warranted because it was going to take place 50 yards from the courthouse in the district attorney's parking lot, the view. He hadn't misbehaved at the trial.
Does it have to be a critical stage of the proceedings, or just,
yes,
or any stage of the proceedings?
Ferreira says any stage of the proceedings.
Is a jury view a critical stage of the proceedings?
Well,
You're saying you
I'm
didn't
saying,
need to get there.
I'm
You're
saying
this
that
one it was.
in these circumstances, because Snyder doesn't say it may never rise to due process, but it says it's not absolutely required. Since Snyder's been Ferreira and other cases that say a defendant has a right to be present at every stage of the proceedings. But I'm saying here, where you're not just looking at the apartment, but you have a mannequin, you have trajectories, you're trying to establish that the defendant, not Madden, was the one who was the shooter, and then you're coupling it with, like, if my point is, if this had occurred in the courtroom, this demonstration, nobody would even for a minute suggest the defendant couldn't be there.
But here you had a defendant who had been away out of the state for 12 years.
Yes.
Couldn't the judge factor in, he's a flight risk. There's some security questions here.
Well, all I would say is the defendant would be transported every day
In shackles.
in Brockton.
In shackles.
In shackles.
And you wouldn't want that done in front of a jury.
Well, that would be, that wasn't really an option given because the judge very quickly said, I'm not going to let him be on the view, given the 12-year absence. But my point is he never misbehaved in the courtroom. He certainly was transported there every day, and the setup in Brockton is that parking lot where the DA is very, it may be 50 yards from the courthouse, but it's not 50 yards from where they bring the defendant in the back parking lot every day to bring him to the trial. And the accommodation was, well, you can look at it out the window. Nothing that the DA was doing inside the car could have been observed from a window up on the second floor in the Brockton court. Nothing could have been heard that the DA was saying. And again, I'm just making the point, it wasn't just looking at a location. It had demonstrative aids and the like with the narrative by the prosecutor as to what was going on. If there are no further questions, I'm all set. Thank you.
Thank you, Mr. Harwood. Good morning, Ms. Lee.
Good morning. May it please the Court. Mary Lee for the Commonwealth, for the Plymouth District. I'll begin with the defendant's statements. The Commonwealth's contention is that the statement that the defendant was thinking about he might need a lawyer, thinking that he might need a lawyer in regards to the case, which is found at transcript 1 on page 138, or he was thinking I might need a lawyer and want to talk with him before talking with you, which is found at transcript, I believe it's 163. I'm sorry, it's transcript 163. That was in the cross-examination of the officer. The Commonwealth contends that that is not sufficient to invoke the rights unequivocally, and we compare this statement to the one in Obershaw, can I talk to a lawyer, combined with a refusal to use the telephone. In Pexado, musing about whether he wanted to continue speaking with the police in the absence of an attorney. In Hussey, there's no affirmative request for an attorney where the defendant unsuccessfully attempted to call the attorney but then decided to wait. In Todd, he wondered aloud about the advisability of having a lawyer. Corriveau, very close. It's beginning to sound like I need a lawyer, and then refusing the telephone. And Penalator, I guess I'll have to have a lawyer for this. None of those were considered to be unequivocal invocation of the right to counsel, and I would suggest that they are comparable to the statement in this case and therefore control. The defendant relies on Contos, where the defendant did say, and Contos said, I think I'm going to get a lawyer, but that was in the context of telling the police to stop and then saying, I think I'm going to get a lawyer. So I would suggest to the court that this is not close enough to Contos. It is closer to the closest to Corriveau and Penalator, which are all cited in my brief. And in that circumstance, the judge was correct in letting in the statements that came in. And I'd just like to, the statements are in a few different parts. So the first statement is not recorded. This case and trial, the interview and trial preceded De Giambattista, but it was not recorded. It was about half an hour, and the officer testified to that. And you can find the contents of that in footnote 4, I believe, of my brief, yes, on page 8. And the defendant does not make any admission to that. His last statement is probably the most close to an inculpatory statement where he says, I'm not admitting to killing anyone yet. But prior to that, he's just admitting who he is. We know who he is because of the fingerprints. We knew that at the time of the interview. He knows who Jeff Tessier is, gives a comment about Jeff Tessier. Jeff Tessier, is the trial shows, is the person who set up the whole stealing the money from the defendant that led within minutes to the killing of Tessier's partner, Anthony LeConte, the victim in this case. So there's some statements that show he is the person they're looking for, but even when shown a picture of the murder scene, the green Monte Carlo, the defendant only says, that looks like a green Monte Carlo. So it's not like you're getting an admission in the unrecorded statement. And then, after they have that unrecorded conversation where he makes no admissions, the closest is, I'm not admitting to killing anybody yet, he says this ambiguous statement, and the officer says to him, are you thinking about it? Do you want a lawyer? And the defendant asks to move to another room and get something to eat.
Was the defense at trial ever that he was not Morganti?
No.
Okay.
No. He was identified by 6 or 7 witnesses, and his aliases and his 12-year flight came in. The officer from the Sheriff's Department in California testified as well, just to describe how he got here. So, but there was no claim that he's not Robert Morganti. He was identified as Robert Morganti or Fasty by all of his compatriots from around the time of the crime who knew him well, including people who claimed to be his friends at the time of the killing. So then he makes his ambiguous statement, and his answer to "Do you want a lawyer?" is "Let's go to another room." So
and that comes in through the officer's testimony.
Testimony, yes.
Okay.
So they move him to a location that is more comfortable.
Is there some reason why let's go to another? I mean, was there something described about the physical
He said
circumstance?
he wanted to go someplace more comfortable.
There was very loud air conditioning, wasn't it?
Something along those lines. He was, and I think he was not warm enough. I think something along those lines. But he wasn't comfortable. He wanted to go someplace more comfortable. So they moved him to someplace more comfortable, that being a location 4 to 5 miles away. So it took no longer than minutes, certainly no longer than a half hour, even with the LA traffic, I would presume, if it's only 4 to 5 miles away.
Did the judge factor that into the Miranda analysis?
No, that
he was
comes in
uncomfortable?
under the Rosario Safe Harbor issue.
No, but in the waiver of Miranda? Did he factor the discomfort into the waiver of Miranda?
When she was looking at whether this was an equivocal statement or not, she found that this was not an unequivocal invocation of rights, and then went to whether there was a Miranda issue.
Did she address the fact that he was uncomfortable
She considered I believe she considered his answer to the clarifying question when she was making the determination whether that was an equivocal statement or not. I believe she did. And I think that's appropriate, because this is not the defendant saying, I want a lawyer, get me a lawyer, give me the phone so I can call a lawyer.
As I listen to you, I take it that you and Mr. Harwood are not disagreeing on the law at all. in other words...
Except for his reading of Contos.
No. What I mean is,
Yes.
if it's equivocal, you go down path B.
Yes.
If it's unequivocal, you go down path A.
Right. If there is an unequivocal invocation of the rights, questioning ceases, and the defendant can start it up again under Edwards and its progeny if he wants to, but that's not what happened here. Here we had a statement. The trooper did not know whether he wanted a lawyer or not, so we asked him that clarifying question, and the defendant didn't say, I want a lawyer.
Ms. Lee, to the extent that we look at post-conduct, namely
Sure.
the quote, what you call the clarifying question, to what extent do we look to see what happened when, I don't know whether the Commonwealth challenges the second part of the suppression, where there was a determination by the trial judge.
We agreed at trial that when he made the statement the second time.
That the state trooper goes on talking.
They do go on talking. They're actually eating at the time. They just started eating their hamburgers, and the defendant says, I think I want to rely on a lawyer for this case. And the trooper...
He again says, I think?
I don't know if he says I think. I can get you the exact sentence. It's
No,
on
we can
page
find it.
A40 of the...
I am thinking I might need a lawyer and want to talk to him before I talk to you.
That's what he says at the end of the
I'm talking about the
unrecorded
later
statement.
Oh, I'm sorry.
At the end of the recorded statement, he says, to tell you the truth, I think I would rather take my chances on a lawyer. You know what I mean?
And that's held to be...
And Judge Giles found that that was an invocation of rights. And after that, and the Commonwealth didn't challenge
The
that.
I think part, she's saying, when you say I think...
It doesn't have the I might in there. In the first statement, he's saying, I think I might need a lawyer for this.
I am thinking.
And want... You're right. I'm thinking I might need a lawyer and
He
want
was
to talk with
thinking
him
he might
before
need a
talking
lawyer.
with you.
But we obviously, this is
There's
just...
no-
the state, this is what the state trooper says, and then he slightly modifies it on cross-examination.
He says, on direct, he says, he's thinking about he might need a lawyer, thinking he might need a lawyer in regards to the case. In the second part on cross-examination, he says, he was thinking I might need a lawyer and want to talk with him before talking with you. The might does not appear in the statement on page A40 of the defendant's appendix, and the judge took that to be without the might in there. The think's in there, but the might's not in there. Took that to be an invocation of the rights and excised everything after. And the Commonwealth didn't challenge that at trial, so we don't need what's after that. We don't want it. There was continued conversation after that. Trooper Coppermath makes a joke when the defendant refers to a lawyer. He says, I'm not buying him, the lawyer, a hamburger too, because Trooper Coppermath had gotten the meal for the defendant. They had just started eating. And then Morganti asks the question. He says, yeah, well, my little sister is 21, huh? Coppermath says, say again. And Morganti, the defendant, says, my little sister is 21, wow. And Coppermath says, you should know how old your sister is. And Morganti says, and then Coppermath says, she might be 23. And they start to talk about his family. And then the defendant starts asking questions about his, how the Coppermath found him. Where'd you look for me? Who'd you talk to? Basically pumping Coppermath for information about the investigation. So I would suggest that to the extent that this court might be concerned that the conversation did not stop when there was an invocation, the defendant began asking questions about his family and then the investigation. So I would suggest that the trooper did not do anything inappropriate in answering those questions and continuing conversation that the defendant initiated then. Then it did move on to further discussion of the case. And so the Commonwealth just didn't put that in out of caution, did not even challenge the judge's ruling on that. And that's appropriate to be cautious when you're trying a first-degree murder case. It doesn't mean that it's not necessarily admissible where the defendant began talking, but at the same time, when we're trying certainly first-degree murder cases, but any cases, we too try to be cautious and make sure that the defendant's rights are not prejudiced in any way. And so then we move on to, so my contention on the first point is that there was no clear statement that he wanted a lawyer. When he wanted to say that he wanted a lawyer, he said it clearly. And he also did that later on when he was talking on the phone. It was not interrogation, but it was custodial statements. He was talking on the phone to the mother of his son. and he was saying, if anybody comes to the house, just don't speak to them. Just say, I wish to speak to an attorney. That's it. The defendant's appendix at page A28. So this isn't a person who doesn't know how to say, I wish to speak to an attorney. He does. And this isn't a person who was trying to end this conversation, was being all pressured. This is a conversational, you'll see it on the videotape. This is a conversational interview, and the trooper is light-handed in this interview, in the portion that's recorded. And the judge was correct. When the defendant made this ambiguous statement, the officer asked him, do you want an attorney? And the defendant did not say he wanted an attorney. He wanted to go to a better location and have something to eat. And that's what he got. And then he got to pump the officer about information about the case and his family. And then we moved to the safe harbor rule. The judge found that the safe harbor rule in Massachusetts cannot apply in California. This was a defendant who was arrested on California charges, an OUI and drug case, and he was being held by the California authorities. And there was no way to bring him for prompt presentment under Rule 7 to a Massachusetts court.
Does the 6-hour rule apply to that kind of an interrogation?
I would suggest that it does not. I would suggest it has an exception right in Rosario. It says also, if for reasons not attributable to the police, such as a natural disaster or emergency, interrogation during the 6-hour period is not possible or must be suspended. The 6-hour period should be told appropriately. So the trooper finds out that there's a fingerprint match on this old murder case. This is 12 years after the killing. He has come into the investigation in the middle. He gets the call.
Why shouldn't the 6-hour rule apply?
Why shouldn't it?
Yeah.
Because from the time he's arrested in California, and we don't even know he's under arrest.
From the time the interrogation starts.
Oh, well, that's all within 6 hours. That's within 2.5 hours.
Does the rule apply, though? The 6-hour rule?
I would suggest, because you can't, there's two purposes for the 6-hour rule. Under the first purpose, it would seem like it would be applicable, because the concern is that the defendant is going to be pressured over the course of 24 hours. How long is he going to have to keep saying, I didn't do it? And so you could see where the analysis in Rosario would apply if this trooper was sitting there with him for 12 hours saying, admit it. And finally, he just wants the interview to end. Okay. So in that sense, Rosario could apply from the time the officer starts talking to him in California. If it does, we're in fine straits there, because there's a 30 to 45-minute conversation that is unrecorded. There is a trip between locations that is 4 to 5 miles. And
what would happen in Massachusetts, too?
I'm sorry?
The trip would have been included in the 6 hours in
Sure.
Massachusetts.
No, she's saying it's all okay.
It's all okay, because and then he talks to him in the California facility for less than 2 hours. You see on the tape, it's like an hour and some change. So
You're saying
the
from
whole
the-
thing's like 2.5 hours, maybe.
From the moment the state super
Gets there,
first
starts talking to him.
meets him, and then to
Till the
when
end
he-
of the interview.
Right.
Even the
Is-
part that's excluded is well within 6 hours. It's under 3 hours. So all of that came in. The judge found Rosario didn't apply, the safe harbor rule didn't apply. I agree with her. They're not in Massachusetts, and that is a rule that is based, now to the second part of Rosario, it's based on the Rule 7 presentment. That's impossible to do because of the interstate agreement on detainers. We can't just go and take him away from California, even if we have a better charge here, a murder in Massachusetts, a higher charge in Massachusetts. We have to go through the process of the governor's warrant, et cetera.
No, of course, nobody's
So
suggesting.
obviously, that's an impossibility to comply with Rule 7, which is the second half of Rosario. I agree with you, though. The first half of Rosario would say you still don't want a Massachusetts trooper to go and sit there across from the guy for 24 hours, deprive him of sleep, and say, "Are you going to admit it or what?" And he finally, that would have a voluntariness issue as well. So if you want to apply Rosario to this case, it should apply when the trooper starts talking to him and end well within the 6 hours when the trooper stopped talking to him after they had their hamburgers. Also, in addition to that, the wiretap violation. This is not a secret recording. First of all, Massachusetts wiretap statute doesn't apply in California. Massachusetts wiretap statute for the application for a warrant is subject to a court of competent jurisdiction, and under Chapter 276, Section 1, search warrants in Massachusetts are limited to the territorial jurisdiction of the Commonwealth and its territorial waters. And the violations of a wiretap under 99P are criminal in nature, and criminal matters outside of the state are not subject to the jurisdiction of the Massachusetts courts or the legislature, and therefore under Commonwealth versus Armstrong, which is an appeals court case cited in my brief, we would have no jurisdiction to apply the wiretap statute to anything that went on in California. If we did, There's no secret recording.
Does,
Right bef-
does the view, let me just shift over to the view.
Oh, sure.
Does in a typical view, is the typical view a critical phase of the trial?
No, because the courts have ruled that the defendant doesn't have to be present at a view.
If it's a typical view, that's
a
probably
typical
correct.
What
view.
if a view is a demonstration, as in this case?
In this case, I don't know if a demonstration is quite the right word. This is a car, because the murder scene was a
Come
car.
on, it's a
So
car.
it's a
you've got
replica car with a mannequin in it, and the mannequin has
That
a
is a
pipe through its head.
demonstration. I
It's-
mean, that
but
is to say,
It's been reconstructed.
it's reconstructed.
It's a reconstructed, exactly, a reconstructed scene. As opposed to the demonstration, I wanted to clarify, all the testimony from the expert about that trajectory and how the murder occurred and how you know where people were sitting,
But he never
that was
got
all
to-
in
he-
court with the defendant present.
He never got to see.
But he didn't see the view.
So how do you answer Mr. Howard's question that if, for example, for some reason this was taking place, they'd brought the car into court. We're now building courtrooms big enough that you could probably do that. Bring the car into court, they do a mannequin, and, you know, if something happens and the defendant is absent. I mean, there's no way that you would say that that's...
Obviously, the defendant has a right to be present at the critical stages of his trial and proceedings. But this court has
I mean,
ruled
the only reason why this is taking place outside
is because it's a car.
is because it's a car. It's not like going to see the building, and it's not to see the car, because we don't take people to see cars unless we have the actual car and we want to show the bullets. We don't take them to see whatever the
Right.
car was, a green something or other. The
Exactly,
reason
yes.
for the view was to look at the...
It's so the jury will understand the testimony that comes later and understand, in a normal view, you go to an
But if
apartment.
the jury has to...
And they know how big the rooms are, and they know you
No,
turn
no,
this
no,
way,
but-
you can't see that way if you're, in that particular room. This car, why was this car important? We wanted to show this, it's the same make and model. The jury knew it's not the same car. The original car had been destroyed because it belonged to Brian Madden. So they knew it wasn't the same car. It was to show the size and positions that people could sit so that they could understand the jury's, the witness's testimony, the expert witness's testimony on why we believe the Commonwealth's theory, rather than we believe, why the defendant shooter would be in the back seat, the victim in the front seat, and Brian Madden.
Aren't you just making the argument why that is pretty critical?
No, I'm saying that testimony came in while a defendant is present and sitting there. And the defendant had the opportunity to look out the window and see this.
But he wouldn't be able to
he couldn't
hear
see
what
that.
was being said.
And he
Would
couldn't
he?
see.
His
through the-
lawyer was there, and his lawyer was making statements, and what was said, and you can see that in the transcript. You can see what was said. They're doing what is appropriate
No,
at
I
a view.
understand. But-
It's pointing things out. I'm sorry.
But if you say the jury needed to see it to help them understand...
No, it's helpful to the jury so that they can better understand the testimony of an expert witness.
Was the
Pictures worth a
defendant ever
thousand
given,
words.
was the defendant ever given the opportunity, perhaps not at that moment, but at some point in time, to go out and see the car and see the mannequin in it?
That wasn't discussed. To my recollection, that's not discussed in the record as a potential remedy for, why, what can he do aside from that.
If we don't agree with you, what's the remedy?
If you don't agree with me, you'll be making a change in the law.
No,
Because
let's assume we don't agree with you. What's the remedy?
I would suggest that this would be harmless. There is no remedy. This would be harmless. And
Because?
because the defendant was present for all the testimony about the car. His lawyer was present at the view. All that was done at the view was pointing things out. You can see that. It starts at transcript 2, page 132. Both the prosecutor and the defendant were there pointing things out. And then both, not just the prosecutor, the defendant's attorney, I'm sorry, I said defendant, I meant defendant's attorney. Defendant's attorney got in the back seat to demonstrate something to the jury and then used that in his closing argument. There's no way a guy could sit in the back seat and hold up the gun and try to shoot at it. It was helpful to the defendant's case, too, to show that this crime couldn't have occurred in that way. And so the defendant properly used it. So this is not harmful to him, and he was given the opportunity to see that. Commonwealth versus Mack, 423 Mass at 291. Defendant could have watched this from a car, and he did not choose to do so, and that was found not to be error. There's no error here.
Was this objected to, by the way?
Yes, the defendant was requesting that he be able to go outside
And there was
for the
no
view.
discussion of alternative security arrangements, or you can see it later.
The alternative was to look out the window, and Mr. Reddington said something to the effect of, I'm not going to have my guy hanging out the window for the view. So, and the conversation then ended without request or suggestion of further remedies.
Was the mannequin or a photograph of the mannequin or a sketch of the mannequin ever made an exhibit or an identification exhibit at trial?
I'm sorry, I don't know the answer. I know the exhibit wasn't, I know it wasn't an exhibit at trial,
Okay.
because I know the mannequin I know the mannequin was not an
typically
exhibit
at
at
the view,
trial.
we get pictures of the building, and sometimes we get the videotape
Right.
of the walk through the building.
So both attorneys got inside this car.
Well, I recall Mr. Reddington's closing argument saying, you remember I got in the back seat and you remember how cramped it was and how's it now he's supposed to be raising his hand up, something along those lines. I mean, Mr. Reddington tried this case very forcefully, and I remember him discussing
And
the
DA
car.
also got inside the car.
I don't
I think
actually...
I saw something.
Yes,
in the
I
car.
accept,
He
I accept
did.
my brother's
Yeah.
statement that he did, because I don't have a specific memory of that. So I would suggest it's used by both parties. It follows the law of Snyder-Gordon. It follows the law of Mack. And there's no error here. The defendant was a huge flight risk. The judge, I mean, he had a strong interest to get back to California to his now 12-year-old son at the time of trial. This is a man who took great efforts to get away. So I would suggest the judge was properly concerned about security. She followed the law. She provided a potential
Well, Mr. Harwood
compromise.
says that the parking lot was just 50 yards away, and
That's in the record about the approximate distance. I know what it looks like, so I don't want to go outside the record to tell you what it looks like, but Judge Giles obviously knew what it looked like. And her security
This is the
concerns...
parking lot in the Superior Court, right? It's that
This is the
part.
Brockton Superior Court and the District Attorney's Office parking lot, which it's in between the two buildings with a street in between.
One point of clarification. Was the warrant for the defendant's arrest issued 12 years before he was in fact arrested?
I want to say the warrant
Or the indictment? Did the
Issued.
indictment issue?
date of the, I want to say the warrant for him issued around the time of the killing, because they knew who they were looking for. And the indictment should be in the defendant's record appendix. It is at page 1, and that issued in 1998, so approximately 10 years after. It was prior to Mr. Morganti's
Arrest in California.
arrest. But my recollection, and I apologize if it's incorrect, my recollection is that there was a warrant pending for some time because they had an idea of who the person was from the get-go, but I could be mistaken on that. The indictment issued 10 years after the murder, and he was then discovered in California in 2000. The trial was in 2003.
Thank you, Ms. Lee.
I would just comment, it was as of May of 1988.
A warrant for his arrest?
Yes.
Thank you. 1988?
Yes.
Yeah.
Yeah. The warrant preceded the indictment.
Thank you.